felt where the wine skies weep, the soil runs red where the farmers sleep. Plasmortar whispers a tale untold of lives cut down in the fields of gold. They say it's crime, just a thief in the night, but the blood on the land tells a darker fight.
A quiet farm in the Eastern Cape, a trusted exchange, and then violence. On February 20th, 2024, Lorain Farm in Blue Water within the Buffalo City Metropolitan Municipality became the scene of a brutal farm attack that left the community shaken and a nation questioning its justice system. This is a story of a crime that was as calculated as it was cruel, and today we uncover the truth behind it.
A cover-up cloaked in a nation's pride, but the graves don't lie where the farmers died. Katie's voice, a fire in the dark, cries for the lost, lights a righteous spark.
Welcome to Blood on the Fields podcast, where we explore the true stories of farm attacks and farm murders in South Africa, honoring the victims, dissecting the crimes, and demanding justice. We are Lucas and Daniel Steenkamp, and today we're diving into the events that unfolded at Lorain Farm in the Buffalo City Metropolitan Municipality.
So farm attacks in South Africa are more than statistics or ordinary crimes, as they are often portrayed by the South African government. They are targeted and calculated acts of terror against families, workers, and communities. They are personal, violent, and leave behind grieving families searching for justice. The numbers are staggering, and the brutality often defies comprehension.
The South African government denies the reality of targeted farm attacks, declaring it is just ordinary crimes and reflecting it as such in the crime statistics. Numbers alone cannot capture the true devastation. Behind every statistic is a name, a life, and a story that deserves to be told. This episode is about one man, Hayden Aldred, and the employees who suffered alongside him. A farm owner whose trust was exploited, whose home became a crime scene, and whose suffering embodies the brutality of farm attacks in South Africa. On 20th Feb 2024, a farm attack incident, which was perpetrated by 6 unknown armed male assailants, prompted the police to obtain statements from 35 witnesses and collate 34 documents or exhibits. This incident was followed by a second episode involving vehicle collision at the N2 Road, Beacon Bay in East London, called the collision scene. The Toyota Land Cruiser, which is counted amongst the properties that were stolen at the farm, escaped the first crime scene and collided with a minibus taxi, a Toyota Quantum, carrying 15 passengers, as well as a Volkswagen Polo carrying 1 passenger. Let's get into the harrowing events that transpired that day. I just want to say the reason why we picked this farm attack as our first episode is because recently some of the perpetrators were brought to justice, and where farm attacks normally are kind of swept under the rug and classified as ordinary crimes, like robberies or house breakings. And with farm attacks, it's generally uncommon for justice to be served. Normally the perpetrators get away, and that is the end of the farm attack, and just marked as a home invasion or a break-in or a robbery. So this one actually led to the conviction of some of the perpetrators. And for the first time in a long time, we actually see justice being served. And it's a very, very recent case. So yeah, that's why we chose to tell this story.
So Hayden Aldred is a proprietary of the farm that operates as a mixed agricultural enterprise, cultivating vegetables and raising cattle. The farm has approximately 70 permanent staff members, and about 200 temporary workers. Among Luck's employees are Bongani Yakani, Maboy Veni, Zameka Galam, and Andile Kangalana. On the morning of February the 20th, Luck and the specified employees were on duty as usual. Around 2 o'clock in the afternoon, which is their lunchtime, 3 men arrived at Lorain Farm. These 3 men politely approached Luck, who was about to drive his Toyota Land Cruiser out of the premises while accompanied by Yakani. They pretended to be buyers interested in purchasing dogs. Their deception worked. Trust was gained, and Hayden Aldred Luck, unaware of their true intentions, together with Yakani and the 3 assailants, drove towards the dog's kennels in his Toyota Land Cruiser. A peaceful conversation between Luck and the assailants carried on without any suspicions from either Luck or Yakani. While still in the driver's seat, the 3 men pointed Luck with weapons, which he believed were firearms. 1 on the side of the driver's seat and 2 on the side of the passenger seat. Yakani, who was at the back of the Toyota Land Cruiser, had already been instructed to lie down. He was tied with masking tape. 1 of the assailants took control of the Toyota Land Cruiser and drove it to the main house. When Luck was instructed to get inside his house, the firearms were still pointed at his person. He too was tied with masking tape as to restrain him from moving. So he was bound, and the nightmare began. The attackers weren't just there to steal. They were there to inflict terror. The farm owner and 4 employees were assaulted, kidnapped, and held hostage. But the worst was yet to come. In the meantime, another 3 assailants simultaneously accosted the other employees with Yakani, Veni, Gilam, and Kangalani. From there, they came to where Luck and the first 3 assailants were and started to ransack the house. 1 of the assailants kept an eye on the employees that were locked in another house and instructed them not to move. The assailants demanded safe keys. It is gleaned from Jalam's evidence that Luck was not in control of the safe keys and monies. His wife, Jackie Luck, which they refer to as Mama Jack, was. As a result, he knew nothing about the safe keys that were demanded from him. This then outraged the assailants, and they started to beat him up and torture him. Because Luck could not tolerate the excruciating pain from the torture, he asked them to call Galam and give him a clue of where the safe keys were. Galam used Luck's phone, which was already taken from him. She phoned Mama Jack whilst under the guard of the robbers. While Galam was phoning Mama Jack, 1 of the robbers had a firearm pointed to her head. Galam politely asked for the keys from Mama Jack and pretended all was well at home. Mama Jack confirmed that the safe keys were in her possession. This also angered the assailants, and they continued to torture Luck. 1 of the assailants took Galam back to where the other employees were and locked the doors and burglar bars. 1 of the assailants, whilst beating Luck up, opened the hot water faucet inside the bathtub and instructed him to lie inside. He did as he was instructed. The hot water started pouring at him whilst he was in lying position. They scalded Luck with boiling water, restrained him, and threatened to dismember him with a chainsaw. They placed a cloth over his mouth while he was submerged in scalding water in the bathtub. The burning of the hot water could not be tolerated. He swiftly removed the bath cap and some water was running down the drain. As he attempted to lift himself up to drain the water, 1 of the attackers pulled out a knife and pressed it painfully against his throat. The assailant threatened. His words were, "I'm going to slit this white man's throat, just like slitting a pig's throat in water." He then dared the attacker to proceed, basically begging him to end his life in order to escape the torture. But the knife was released and his face was again covered with a cloth, and the torture continued. This was not just a robbery, it was an act of calculated brutality and terrorism. As a result of the torture, Luck sustained multiple injuries, including cuts on his head from being struck with a firearm. There was widespread bruising on his chest, ribs, and other areas. He sustained facial swelling and discoloration. There were blisters on his buttocks emanating from being submerged in scalding water. Luck begged the assailants to ask for tools from one of his employees so as to break the safes and take whatever they wanted to take. Kangalana was called to look for the electric grinder and crowbar. When he lifted the garage door, one of the assailants hit him with a firearm. He could not tolerate the pain and the shock that he found himself in, and asked him to call Venny to get the tools instead. Venny was instructed to look for the tools, which he found. When they couldn't open the safes, the assailants broke the door. They ripped them from the walls and removed the safes. Venny was instructed to assist in loading the items, including the safes, which had firearms and money inside, into the Land Cruiser. Since there were two motor vehicles in the yard, the Toyota Land Cruiser and Toyota Hilux, one of the assailants ordered that both vehicles be driven out of the premises. This was adhered to. The 6 assailants left the scene in possession of properties, firearms, and cash valued at approximately 2.3 million. They drove towards East London at extremely high speed. The news regarding the robbery at Luck's place was circulated via the WhatsApp group of community members. Those among the community members who could follow the lead did. Amongst those who were chasing Luck's Toyota Land Cruiser were Carl Heeman, who was in company of Johannes Janssen, as well as Christy Rusto. Heeman and his co-driver witnessed how the collision between the Toyota Land Cruiser, Volkswagen Polo, and the Toyota Quantum occurred. He observed people flying out of the Quantum due to the collision. Immediately after the collision, the driver of the Toyota Land Cruiser, accused number 1, escaped the collision scene and went to the bushes. Based on his observation at the collision scene, Heeman noticed that the driver of the Toyota Land Cruiser who ran to the bushes was tall and white in complexion. He had a floppy hat on his head. One of the occupants, accused 2, was left at the collision scene with visible injuries. He was apprehended at the collision scene. According to Sergeant Mtati's testimony, he found accused 2 lying at the collision scene, covered in dust, bleeding and injured. Upon obtaining consent to search him, he discovered 4 live ammunitions, including a live ammunition of a rifle in his pocket. In addition, he found a wristwatch which was later identified as belonging to Mama Jack. These items were exhibited and depicted in photographs that formed part of the court's exhibits. Msebisi Sinkwana, a resident at the Nompalelu village, testified that the tarred road where the collision occurred is not far from his home. On the day of the incident, he noticed that an accident had occurred due to high, unusual volume of cars at the road. While at home with his girlfriend, accused 1 appeared with visible injuries. He spontaneously informed them that he was being pursued by the police for stealing a vehicle in Mooiplaas. He bandaged accused 1's injuries and borrowed him his jersey, as he complained of feeling cold. Because he was afraid, Sinkwana swiftly asked his neighbor to call the police. The neighbor took some time to return. He then walked accused 1 towards the direction of Minky Tavern. It was there that the police emerged, prompting accused 1 to flee. Accused 1 was chased and subsequently apprehended by the police, including Constable Barney Don, who testified to that effect. After learning about the robbery at Luck's home, Restore drove to Settlers Way, towards the direction of town. Upon arriving at the collision scene, he found one of the suspects, accused 2, already handcuffed. Restore assisted the police by searching the area, including the tunnel, for possible evidence such as hidden firearms and other relevant clues. As he walked through the tunnel, he spotted an abandoned jacket approximately 10 meters from the exit. The jacket appeared clean, suggesting that it had been discarded recently. It featured distinctive yellow and white patches on the sleeves. Concerned that someone might find and conceal it, he took the jacket and handed it over to Sergeant Mkhudwa, who registered it in the SAP register.
SAPI, South African Police.
Oh yeah, okay. Accused 3, a Bolt driver, was alleged to be involved at the farm attack in that the vehicle may have been used as a getaway car after the commission of the crime. This argument is based on the discovery of accused 3's Volkswagen Polo without a front number plate, approximately 200 to 300 meters from the first scene, which subsequently led to his arrest. There were 15 passengers in the Toyota Quantum. 13 of them gave testimony, except for Mrs. Nongeti Foki, who passed away at Freya Hospital on 27 May 2024. Although the passengers could not directly witness the incident, their accounts were similar. They stated that they heard a bang, and only to discover that the Toyota Land Cruiser had collided with the back of the Quantum. The Toyota Quantum flipped over, resulting in a mix of minor and severe injuries among the passengers. Preston, who was a driver of the Polo involved in the collision, witnessed the collision and attributed the cause to the reckless and inconsiderate driving of the Toyota Land Cruiser. Specifically stated that the Toyota Land Cruiser's excessive speed led to the collision. It is undisputed that as a result of the collision, the Toyota Land Cruiser veered off the tarred road and became lodged in the rails. The vehicle had significant damage and was subsequently declared a total loss or write-off by the insurance company. Meanwhile, the second bakkie, the Toyota Hilux, which had escaped the first scene during the robbery, was abandoned on Hudson Avenue, still in a good condition. Following the arrest of accused 1 and 2, as well as the collection of witness statements by the police, Luck and his employees indicated that they could potentially identify the suspects. So on the 1st of March 2024, an identification parade was held. During the parade, 15 males participated, including accused 1 and 3. The results of the ID parade were as follows. Veni, Yakani, and Luck identified accused 1. Kangalana identified accused 1 and an unknown person. Galam, who appeared to be terrified and nervous, identified an unknown person, specifically the individual standing as number 15 in the lineup. Although accused 2 did not participate in the ID parade, Luck pointed him in the dock as one of the assailants. When questioned about his identification, Luck explained that he recognized accused 2 because he was wearing a white t-shirt during the incident. He was the one who held a knife on his throat, threatening to kill him. Accused 2 also participated in throwing him inside the bathtub. He further inquired about the whereabouts of the electric grinder and the crowbar. Subsequent to the arrest of accused 4 on 9 February 2025, a second ID parade was held. Luck, Veni, and Kanglana identified accused 4 in the ID parade. As a consequence of these events, the Director of Public Prosecutions for the Eastern Cape Division instituted prosecution against the 4 accused. Some of these charges relate to accused 1 only. So from this part basically onwards, we'll just be reviewing the court document which we obtained, also to make sure that the information we gave is correct. We'll also attach the court documents
in PDF form or a link.
So you guys can also go through the court documents.
Basically the whole script is based off of the court document anyway, but we'll put the original court document posted for you to access in some way or the other.
In the High Court of South Africa, the Eastern Cape Division in East London, Judge N. Singani Mbakaza, the acting judge of the High Court, presided over the case. In the matter of the State versus Odwa Diabana, accused 1, Lutandu Nkangalizwe, accused 2, Lundi Mahubongu, accused 3, and Siseku Kwayisu, accused 4. The court case took place over a period of 19 days, between the 25th February 2025 to the 29th of May 2025. The verdict was delivered on the 30th of May 2025. All accused testified in their defenses. Accused one's version will be summarized as follows. On the day before the incident, he was in Mdatsani, where he met a woman and developed a fleeting romance. Together with the girlfriend, they went back to look for her friends. However, their encounter became sour when the girlfriend's boyfriend appeared. He became jealous and assaulted him. After fleeing from assault, he took refuge in the forest. He met a kind stranger who was in the company of a woman and a child. The stranger took him to his house, borrowed him a jersey, and tended to his injuries. Accused one later went to look for Miniqui's tavern. On the way, he was spotted by another stranger who pointed him out to the community members, saying, "There he is." He was subsequently caught. Accused one testified that after being apprehended, he was severely assaulted and sustained injuries to his face. Police took him to the collision scene and later to the police station. At the police station, some police officers suggested that he be taken to the doctor. After the doctor's treatment, he was detained. Accused one denied that he committed the crimes as alleged by the state. Accused two testified that around 1:30 he left his village in Mooiplaas to head to East London. He hitchhiked and spotted a Toyota Land Cruiser being driven recklessly at a high speed. This Toyota Land Cruiser was being followed by a bakkie. The driver stopped and offered him a lift.
Sorry to interject. A bakkie is, for our American friends, a pickup truck. In South Africa, it's known as a bakkie. Like a Toyota Hilux or a Ford Ranger, it's a bakkie.
The driver of the Land Cruiser stopped and offered him a lift. He got at rear section at the driver's request to hold a cupboard. While
Safe.
What? Where's in his safe?
No, the cupboard is the safes that they stole from the...
Oh!
But it's his account.
Okay.
Okay, it's just interesting that you see a guy in a Land Cruiser bakkie drive recklessly, and he hitchhikes and he stops.
To get in
To
for
get
a
in.
lift.
Not like suspicious at all, his account of the...
Okay, so he got it in and he's holding a cupboard, which is the safe. While riding in the speeding vehicle, he noticed a firearm lying nearby. He thought it might be a toy gun. The Toyota Land Cruiser was soon chased by police. As it was speeding, he heard a loud bang and found himself on the ground, having lost consciousness. When he regained consciousness, he realized that an accident had occurred. Accused two denied his involvement in the commission of the crimes as alleged by the state. Furthermore, he denied that Mama's Jack watch and a set of 5 ammunitions were found in his possession during the arrest. When asked to explain about the DNA found in Luck's firearms that were in the Toyota Land Cruiser, he testified that the firearms might have touched him during the accident, potentially transferring his DNA.
That's very probable, like getting picked up by a reckless driving, speeding Land Cruiser because he hitchhiked.
2 fingerprint experts, whose credentials were undisputed, testified about the independent analysis of the fingerprints found at the first crime scene. Warrant Officer Lionel Diakop visited the first crime scene on the day of the incident and collected DNA samples from the gear lever and steering wheel of the bakkie, which was recovered at Hudson Avenue. He also discovered a sellotape mask inside the kitchen and a cloth in one of the bedrooms. Allied to those discoveries, he lifted fingerprints from the sellotape item, which was on top of the chair. He further took photographs of the kit he used, including the spot where the fingerprints were lifted. On the 25th of February 2024, Warrant Officer Diakop received a set of fingerprints from the investigating officer. These were obtained at the time of arrest. Upon comparison, the fingerprints matched those obtained from the investigating officer, identifying accused one. On the day of his testimony, he prepared a court chart by first taking fresh fingerprints from accused one and conducting a second analysis. The fresh fingerprints, along with those from the sellotape and the investigating officer's submissions, confirmed a match, conclusively linking them to accused 1. Captain Calvin Swartboy testified about his multifaceted role in the case: official photographer, duty officer, fingerprint expert, and crime scene investigator. He referenced to the photographs he took and stated that he lifted fingerprints and collected DNA from the firearms found in the Toyota Land Cruiser. He used an automated system to compare fingerprints found in the Toyota Land Cruiser with those obtained from the investigating officer. The results came out identifying accused 2's fingerprints. To further confirm, he took fresh fingerprints and prepared a court chart. The second comparison also identified accused 2. Although he lifted a lot of fingerprints from the Land Cruiser, the fingerprints that positively identified accused 2 were those lifted from the Toyota Land Cruiser's fender. Sergeant Sully, one of the witnesses, testified that although he did not have details of how accused 3 was arrested, he took his warning statement. He submitted a standard police form used to obtain warning statements. The communication was in Xhosa, a language understood by accused 3. Before proceeding in writing a statement, accused 3 was informed of his right, including the right to legal representation at his own expense or through legal aid, as well as the right to remain silent. He was also cautioned that any statement made could be used against him in court during a subsequent trial. Accused 3 acknowledged understanding these rights and proceeded to make a statement. His statement reads as follows: I deny the allegation against me that on Tuesday, 20 February 2024, was phoned by Odwa, who is a friend to me, and asked me to take him to Mooiplaas, together with his friends who were unknown to me. I met Odwa at Igoli near Buffalo Flats, together with Odwa's friends, who were about 5 in total. I proceeded to Mooiplaas with them. On arrival at Blue Water, I took the left turn and stopped in the gravel road, and all of them alighted from my Volkswagen Polo with registration number. It was charcoal in color and hatchback. After that, I drove my vehicle to park at the taxi rank along the main road. After a while, I noticed a Toyota Land Cruiser bakkie, beige in color, and a white Toyota bakkie from a gravel road with a high speed, following each other to the direction of East London. I then followed also to the direction of East London. I'm not sure of the drivers of the 2 bakkies. That is all I can say about this matter. Siyabonga Mpusula testified that accused 3 normally fetched his aunt's child from school, but on that day of the incident he failed to do so. His aunt asked him to take charge. After some time he received a voice note from the cell phone number
Redacted.
from accused 3 explaining that he was delayed, attending a business at Mooiplaas, and he would not be able to fetch the child. Mpusula identified the Polo in the exhibited photographs as belonging to accused 3. He later presented the cell phone number to the investigating officer. Accused 3, a Bolt driver, testified that on the day of the incident, he had been driving a child to school as usual. Around 9 a.m., he received a request via the Bolt app to transport passengers to Blue Water for a fare of 600 Rand. To avoid Bolt commission, he made a private deal with the passengers, cancelling the formal road trip authorized by Bolt. As a result, he relied on the passengers' directions since the app was off. Although delayed by road constructions on the way, he eventually dropped off the passengers before they could reach their destination. Upon returning, he noticed his mud flaps were missing and later finding them. While fixing the mud flaps, he discovered that the front number plate had been dislodged and was lying under the car. Accused 3 admitted being in the vicinity for legitimate purposes, as depicted in the still photographs, but denied involvement in the crime. He also confirmed phoning
Mpusula.
He also confirmed phoning Mpasula to assist in fetching the child from school, but denied making a warning statement to the police. Accused 3 confirmed knowing accused 1 and 2, but claimed no knowledge of accused 4. He testified that he could not recall the identities of his passengers that day, but was certain that accused 1 and 2 were not among them.
Sorry if I can just interject. Earlier in his testimony, he said that accused 1 phoned him and asked him to take them to Mooiplaas, him and his friends, which were 5 in total. And now he says that accused 1 weren't among them. So, I mean, he's contradicting his own testimony. Yeah, and also, very funny, the state accused him of being involved because they found him close to the crime scene at the farm with the number plates removed from the car, suggesting that he might be the getaway vehicle, which seems quite probable. But now he says he found it underneath the car when he fixed his mud flaps. It's just a lot of very suspicious and contradicting
behavior.
Yeah.
The debate surrounding accused 3 centers on his absence from the crime scenes. Counsel for the state argued that despite his absence, it can be inferred that he had prior agreement with accused 1 to participate in the commission of the crime. The state's argument is based on the discovery of accused 3's Volkswagen Polo without a front number plate, approximately 200 to 300 meters from the first scene. This suggests that the vehicle may have been used as a getaway car after the commission of the crime.
Which is the way I would see it.
Counsel for accused 3 argued that the evidence linking accused 3 to the crimes is insufficient to sustain a conviction, particularly in light of his detailed explanation for being in the vicinity of the first crime scene. Accused 4 testified that on the day of the incident, he was with his girlfriend, Bukiwe, at her place, trying to resolve a conflict they had had. He testified that his injuries from the days prior made it impossible for him to commit the crimes, as he was limping. He also provided his cell phone number to the investigating officer. When confronted with the cell phone records showing his cell phone was used near Blue Water during the robbery, he denied this, insisting that his cell phone was non-functional at that stage. Accused 4 confirmed knowing accused 1, but claimed no knowledge of the others. Accused 4 raised concerns about the ID parade procedure, alleging that the investigating officer took his photograph beforehand. He also claimed that although he was given the opportunity to change clothing and directions, which he declined, he was not allowed to choose the participants in the ID parade. Melissa van Rooyen, an intermediate life support paramedic at ER24, testified that around 20 to 4 on the day of the incident, she attended to the collision scene with her colleague, who had advanced support skills. She found a lot of passengers with minor to serious injuries. She attended to the deceased, who lay on the grass. The deceased was still alive, complaining of severe neck pain and numbness in her limbs. Van Rooyen administered a drip and transported the deceased with her colleague's assistance to Frio Hospital. The deceased sustained no further injuries from the time she was taken from the collision scene up to a stage when she was admitted in hospital. On the 25th of February, Van Rooyen visited the deceased in the ICU care unit for a follow-up. The patient was still able to talk, complaining of being paralyzed completely. This was the last time Van Rooyen saw her. Dr. Siatindwe Kunyuza, a medical practitioner, conducted a post-mortem examination on the deceased's body. The findings included C4 and C5 dislocation structure and enlargement of the head. C4 and C5 dislocation fracture refers to the 4th and 5th vertebrae in the neck region of the spine. The key implications are that there was severe neck injury. In the result, the cause of death was determined to be a spine injury consistent with a motor vehicle accident.
Okay, this is the judge's discussion about the case and all the evidence. Counsel for the state sought convictions of all accused, making concessions regarding counts 26, 31, 32 and 33. These counts pertain to possession of unlicensed firearms under Section 3,1 of the Firearms Control Act 60 of 2000. Notably, counsel for the state highlighted Exhibit C, which shows, among other things, that the firearm in count 26 was incapable of discharging the ammunition. The firearm was among those stolen during the robbery at Luck's home. In contrast, counsel for accused one submitted that the contradictions in the state's witness testimony regarding accused one's clothing suggest an honest mistake in relation to the perpetrator's identity. This includes a mistake made by Heman, who testified that he saw accused one jumping out of the stolen Toyota Land Cruiser after it overturned. Most importantly, so he argued, the credibility of the ID parade and the presence of accused one's fingerprints on the masking tape allegedly lifted at the scene are questionable. In support of this proposition, accused one's counsel pointed out that Luck's evidence indicated that no fingerprints were lifted from his premises. Counsel for accused 2, 3 and 4 argued for the acquittal in respect of all charges. He argued that the version of events is more probable than that of the state. Counsel argued that it was plausible for the stolen items to be found where accused 2 was because he had coincidentally hitchhiked the stolen vehicle. He also disputed the claim that the items were found in accused 2's pocket, given that he was unconscious after the accident. Additionally, counsel raised similar concerns to those of accused 1's counsel, specifically regarding the ID parade that impacted accused 4. My duty is to weigh all the elements which points towards the guilt of the accused against all of those that indicate his innocence. In addition, I have to evaluate the evidence in its totality, taking into account the inherent strengths and weaknesses, probabilities and improbabilities of both sides. Ultimately, I must analyze and decide whether the burden weighs so heavily so as to exclude any reasonable doubt about the accused's guilt. Despite the defense's oral submissions, I am satisfied that the state has met the legal requirements as outlined in Ntemwa. The overwhelming evidence suggests that accused 1, 2 and 4 were at the crime scene. The chain evidence regarding the ID parades was not disputed by the defense. Instead, the defense argued that the ID parades were improperly conducted due to differences in the height, width, and clothing among the participants. However, this argument is unconvincing, given that accused 1 was represented during the first ID parade. After considering the evidence from those in charge of the ID parades, I conclude that both were properly conducted. The reliability of the ID parades is further supported by the fact that some witnesses pointed out irrelevant persons, including Galim, who failed to identify anyone, indicating an objective process. Okay, I just want to pause here for a second. Remember, there were 6 assailants. The 3 that took Hayden, Aldred, Luck to the house, another 3 that brought the other workers, 1 was the getaway driver, or well, alleged. So, 6 altogether. With the ID parades, accused 1 was pointed, and then there were also another 2 that was pointed out by Luck. One was by the Luck and the other one was by one of his workers, but they were never charged. And here we have 4 accused, one of which is the Polo driver or the Bolt driver. The other 3, and with the other 2 that were pointed out, it would have been 6. But okay, they say it was irrelevant persons. But anyway, probably they didn't have any evidence to place them at the scenes. But it would have been 6. At this point, it is further opposed to present the corroborative evidence which confirms that the perpetrators were correctly identified. The incidents occurred during daylight. The witnesses, to wit Veni, Kangelana and Luck, though terrified, identified accused 1, 2 and 4's faces. Accused 1 and 2 were arrested immediately after the commission of the crimes. Accused 1's spontaneous admission to Sinqua about stealing a car aligns with Heman's testimony, who saw him jumping out of the Toyota Land Cruiser after the incident. This is also corroborated by the evidence of Rustov and Constable Ralton Nelson, who found the jacket and the hat, which items were identified as those worn by accused 1 during the commission of the crimes. Furthermore, accused 1 and 2 were found in possession of the stolen goods, including the Toyota Land Cruiser immediately after the commission of the crimes in question. Accused 2 was found in possession of the wristwatch belonging to Mama Jack, it's Luck's wife, as well as ammunition stuck in his pocket. This then reminds me of the doctrine of recent possession, which infers guilt and someone is found in possession of stolen goods soon after the theft. I acknowledge the principle in State versus Square, where the court noted that the nature of the article is an element in the determination of what is recent. In Square, the court stated that if the article stolen is of the type which is usually and can easily and rapidly be disposed of, anything beyond a relatively short period will usually not be recent. In the matter under consideration, the state presented a distinct scenario. Although watches, ammunition and cars can easily move from one hand to the next, the accused were pursued by the police and community members after the crimes. It is therefore clear that the doctrine of recent possession applies, particularly given the immediate recovery after the chase. Additionally, the prints found at the scene and those found at the Toyota Land Cruiser's fender, including the accused two's DNA found at Luck's firearms, carry a strong objective probative weight in linking both accused 1 and 2 in the commission of the crimes. The fingerprints experts testified in coherent, consistent and credible manner in explaining the process of the lifting of fingerprints and DNA in question until the final analysis was conducted. There is no evidence to rebut the experts' testimonies in this regard. The presence of the accused two's DNA, which was lifted in Luck's firearms, contradicts his ability and supports Luck's testimony, suggesting that he was present at the scene of crimes and participated when the firearms were lifted in the safes. Accused two's alibi is indeed improbable. It is implausible that a driver fleeing from police would offer a lift to bystanders. Luck's explanation on this point was convincing to the court. It is therefore crucial to mention that the evidence of accused 1, 2 and 4 cannot be reasonably possibly true in the circumstances. The evidence needs a lot to be desired. There is no valid explanation why the alibi of accused 4 was not put to the witnesses for them to comment. Even if such version were put to the witnesses, the overwhelming evidence negates the alibi in question. Furthermore, the contradictions regarding accused 1's clothing, as highlighted by both the state and the defense, are immaterial. Despite these minor discrepancies, the probability strongly suggests his involvement as one of the perpetrators. Even applying cautionary rules to Heman's single testimony about seeing him jumping out of the Viet Toyota Land Cruiser, there is substantial corroborating evidence implicating him in the crimes. Despite the overwhelming evidence linking accused 1, 2 and 4, the same cannot be said about accused 3. The state relied on circumstantial evidence which is governed by two principles, and these are: the inference sought to be drawn must be consistent with proven facts. The proven facts must be such that they exclude every reasonable possibility, save the one to be drawn. In relation to accused 3, the state faces significant challenges. His version raises a question about familiarity with accused 1. The warning statement, suggesting prior agreement for a business trip with accused 1 and others, as well as his delay in leaving the crime vicinity after dropping off the passengers. Given accused 3's testimony, where he provided detailed explanations and answered state's questions, it is difficult to exclude every reasonable inference. His explanation as a bold driver, attributing delays to a tire problem, road construction, and a lost number plate remains unrefuted and creates doubt about his guilt. The issues for determination are whether the accused were correctly identified as perpetrators for the crimes in question. Allied to that, the court must examine whether the perpetrators acted in common purpose in order to act in furtherance of a shared criminal design. Another point in issue is whether the perpetrators collectively possessed unlicensed firearms and ammunition as alleged by the state. Furthermore, the court must determine whether accused 1 had intention to kill the deceased and whether he had intention to attempt to kill 13 passengers, including 1 motorist. Well, I would say driving and speeding recklessly already demonstrates intent, but yeah, this is South Africa. In South African law, the standard proof that has been consistently reaffirmed through various cases is proof beyond reasonable doubt. For an acquittal, the version of the accused need only be reasonably possible true. In Shackle versus State, the court held per brand AJA, a court does not have to be convinced that every detail of an accused version is true. If the accused version is reasonably possibly true, in substance the court must decide the matter on the acceptance of that version. Of course, it is permissible to test the accused version against the inherent probabilities, but it cannot be rejected merely because it is improbable. It can only be rejected on basis of inherent probabilities if it can be said to be so improbable that it cannot reasonably possibly true. Where identity is at issue, the court must approach witness evidence with caution. The caution approach assists to ensure reliable identification. This means that the state must present credible, reliable, and sufficient evidence to meet the high burden of proof demonstrating accused identity beyond reasonable doubt. The principle in State versus Mthethwa as a guiding authority in assessing whether the perpetrators of crimes were reliably identified. In this case, the court had the following to say: because of the fallibility of human observation, evidence of identification is approached by the courts with some caution. It is not enough for the identifying witness to be honest. The reliability of his observation must also be tested. This depends on various factors such as lighting, visibility, and eyesight, the proximity of the witness, his opportunity for observation, both as to time and situation, the extent of his prior knowledge of the accused, the mobility of scene, corroboration, suggestibility, the accused face, voice, build, gait, and dress, the result of identification parades, if any, and of course, the evidence by or on behalf of the accused. The list is not exhaustive. These factors, or such of them as are applicable in a particular case, are not individually decisive but must be weighed one against the other in the light of the totality of the evidence and probabilities. Although this case involves numerous legal principles, to contextualize issues, I will pause here and proceed to the discussion. Regardless of the overwhelming evidence against accused 1, 2, and 4, the state bears onus on proving beyond reasonable doubt that the accused acted in concert to achieve a common goal. At paragraph 21 of its judgment, the Constitutional Court in Thebes and another versus State noted that the principles laid down in Ngezi versus State were since refined and developed by the Supreme Court of Appeal in various authorities. The Constitutional Court per Mosenke reaffirmed the principles of common purpose and held. The doctrine of common purpose is a set of rules of the common law that regulates the attribution of criminal liability to a person who undertakes jointly with another person or persons the commission of a crime. Burchell and Milton define the doctrine of common purpose in the following terms: where two or more people agree to commit a crime or actively associate in a joint lawful enterprise, each will be responsible for specific criminal conduct committed by one of their number which falls within the common design. Liability arises from their common purpose to commit the crime. Snyman points out that the essence of the doctrine is that if two or more people having a common purpose to commit a crime act together in order to achieve that purpose, the conduct of each of them in the execution of that purpose is imputed to the others. These requirements are often couched in terms of which relate to consequence crimes such as murder. The liability requirement of a joint criminal enterprise falls into two categories. The first arises where there is prior agreement, express or implied, to commit a common offense. In the second category, no such prior agreement exists or is proved. The liability arises from an active association and participation in a common criminal design with the requisite blameworthy state of mind. In the present case, the evidence does not prove any such prior agreement. Notwithstanding this, the overwhelming evidence explicitly demonstrates a joint enterprise among the accused 1, 2, and 4, with all actively participating in the criminal activities. Revisiting the applicability of common purpose to joint possessions of firearms and ammunition is essential. The court's consideration would involve examining whether all the accused shared knowledge, intent, and active participation regarding the firearms and ammunition, beyond general participation in the crimes. The joint possession of Lux firearms seemed evident, given the accused's collective actions during the commission of the crimes, including breaking safes and escaping with firearms. This shared involvement supports the notion of joint possession. To determine joint possession for specific firearms used during the commission of the crimes pointing at Luck and Gillum, as well as hitting Kagelana, it is crucial to assess whether all the accused had knowledge, intent, and control over those firearms, particularly if their use was part of the shared criminal design. The evidence of accused 1 and 2's possession of gun-like objects remain unshaken. Given the manner in which the crimes were committed, including active participation by accused 1 and 2, accused 4 cannot be disassociated from the use of the firearms, which were used to threaten Luck and his employees during the commission of the crimes. It is conclusive that when he participated, he joined accused 1 and 2, who were already armed, foreseeing the possibility of the firearm use and reconciling himself with it. Clearly, his intention was to commit crimes together with others using gun-like weapons to threaten victims and facilitate escape with stolen goods and Lux firearms. Counsel for the state cited State versus Kwekwe and argued that accused 1, while escaping in Lux Toyota Land Cruiser and collided with the Toyota Quantum, as well as a Polo, intended to attempt to kill the 13 passengers in the Toyota Quantum, including a motorist. He further argued that accused 1 had the intention to kill the deceased. Counsel asserted that in both instances, accused 1's intention was in the form of dolus eventualis, meaning he foresaw the possibility of death occurring and reconciled himself with that probability. The well-known legal position is that intention is ordinarily inferred from the facts of the case through inferential reasoning. For intention in the form of dolus eventualis, the test is subjective, involving both cognitive and cognitive elements. This supportive test must not be conflated to an objective test which is applicable in cases involving negligence as an element. The facts in Kwekwe are distinguishable from the present case. In Kwekwe, the accused drove a stolen vehicle, striking children on the sidewalk while being pursued by the police. The court found dolus eventualis based on clear evidence, including the sketch plan detailing the motor vehicle and the children's position at the time of the collision. Notably, Kwekwe predates the Supreme Court's appeal through examination of dolus eventualis in motor vehicle collision cases. The following key considerations are crucial in the circumstances of this case. The accident circumstances surrounding the accident are not as clearly detailed as above in Kwekwe. The deceased died over 3 months after the collision. The witnesses only reported hearing a bang at the back of the Toyota Quantum and could not provide further insight into what actually happened. The evidence of some of the witnesses demonstrate accused one driving at high speed, overtaking inconsiderately and failing to stop at an intersection, which to me proves intent, but anyway. Therefore, in light of the aforesaid, it is reasonable to infer that accused one, as an adult who was speeding and overtaking other cars recklessly, foresaw the possibility of the potential harm caused by his manner of driving, including death. The key question is whether he subsequently reconciled himself with that possibility. The evidence is insufficient to demonstrate bullshit. The evidence is insufficient to demonstrate that accused one had reconciled himself with the risk involved. Instead, the evidence overwhelmingly suggests that accused one was trying to escape police pursuit, driven by false confidence and bravery in outrunning them. Therefore, the convictions on 13 counts of attempted murder and 1 count of murder cannot be sustained. Disagree? Despite the insufficiency of evidence in the attempted murder and murder charges, one must examine whether accused one is not criminally liable for the negligent killing of the deceased. The test for negligence was summarized in the well-known judgment of Creer versus Kutsia, where the court held that if a reasonable person would have foreseen the possibility of harm and would have taken reasonably steps to prevent it from happening, and the person in question did not do so, the element of negligence is established. In case accused one failed to exercise the standard of care expected of a reasonable person in the circumstances. According to Dr. Kunyuza, the deceased injuries were consistent with motor vehicle accident. Therefore, accused one's actions, namely driving a motor vehicle recklessly, as demonstrated by witnesses and accused two, as well as the failure to observe traffic rules, showing disregard for safety and all factors that contributed to the deceased's death. Furthermore, given accused one's reckless manner of driving, as observed by state witnesses including accused two, a conviction for reckless driving that caused harm to passengers in the Toyota Quantum and a motorist is inescapable. And Daniel can do the convictions.
The final issue concerns the rule against duplication of conviction. While the state has its discretion to frame charges as it deems fit, the court retains a discretion to guard against duplicative conviction. It is necessary to promote fairness of the trial on both sides and to avoid prejudice to the accused. Punishing an accused multiple times for a single offense would be unfair and violate the principle of justice. In my view, count 1, pointing of a firearm at Luck, and count 2, robbery with aggravated circumstances, constitute a single transaction. The accused action, specifically putting Luck in a bathtub with hot water, constitute a separate charge of attempted murder. This is further supported by accused two's declaration, who stated that Luck's throat would be slit like a pig, indicating a clear attempt to kill. Similarly, the charges of kidnapping stand as the accused clearly formed distinct intentions, including restraining the employee's freedom by confining them in one room while committing the crimes. Regarding the pointing of firearms against Galam, it is clear from her evidence that her cell phone was not among the stolen items. However, there is overwhelming evidence that the accused demanded safe keys, pointed a weapon believed to be a firearm at her. It may well be argued that this is a single intent in pursuit of robbery against Luck. However, the firearm and the demands were directed to a different person, to wit Galem. The conviction outcome demonstrates that although Galem was harmed, her cell phone was never stolen, resulting in a competent verdict. Regarding counts 26, 31, 32 and 33, the state's concessions are correct. The essential elements of the offences of unlawful possession of a firearm, as contemplated under Section 3 of the Firearms Control Act 60 of 2000, were not proved beyond reasonable doubt. In the result, the verdict is pronounced as follows. Accused 3 is found not guilty and discharged in respect of all counts. Count 1, pointing of a firearm in contravention of Section 126, read with Sections 1, 121 and Schedule 4 of the Firearms Control Act 60 of 2000, accused 1, 2 and 4 are found not guilty and discharged. Count 2, kidnapping. Accused 1, 2 and 4 are found guilty as charged. Count 3, robbery with aggravating circumstances as defined in Sections 1, 1b of the Criminal Prosecution Act of 1977, accused 1, 2 and 4 are found guilty as charged. Count 4, robbery with aggravating circumstances as defined in Sections 1, 1b of the Criminal Prosecution Act 51 of 1977, accused 1, 2 and 4 are found not guilty and discharged. However, accused 1, 2 and 4 are found guilty to pointing of a firearm in contravention of Section 126, read with Section 1, 121 and Schedule 4 of the Firearms Control Act 60 of 2000. A competent verdict. Count 5, attempted murder. Accused 1, 2 and 4 are found guilty as charged. Count 6, kidnapping. Accused 1, 2 and 4 are found guilty as charged. Count 7, kidnapping. Accused 1, 2 and 4 are found guilty as charged. Count 8, kidnapping. Accused 1, 2 and 4 are found guilty as charged. Count 9, kidnapping. Accused 1, 2 and 4 are found guilty as charged. Count 10 to 22 in respect of accused 1 only. Accused 1 is found not guilty and discharged in respect of all counts. Count 23, murder. In respect of accused 1 only. Accused 1 is found not guilty and discharged. However, accused 1 is found guilty to culpable homicide, a competent verdict. Count 24, reckless driving in contravention of Section 63.1, read with Section 89.1 and 89.5a of the National Road Traffic Act number 93 of 1996, in respect of accused 1 only. Accused 1 is found guilty as charged. Count 25, 27, 28, 29, and 30. Unlawful possession of a firearm in contravention of Section 3.1a, read with Sections 1, 120, 121, and Schedule 4 of the Firearms Control Act 60 of 2000. Accused 1, 2, and 4 are found guilty as charged. Count 26. Unlawful possession of a firearm in contravention of Section 3.1a, read with Sections 1, 121, 121 and Schedule 4 of the Firearms Control Act 60 of 2000, accused 1, 2, and 4 are found not guilty and discharged. Count 31. Unlawful possession of a firearm in contravention of Section 31A, read with Sections 1, 120, 121, and Schedule 4 of the Firearms Control Act 60 of 2000, accused 1, 2, and 4 are found not guilty and discharged.
The same with count 32 and 33.
Count 34. Unlawful possession of ammunition in contravention of Section 90, read with Sections 120, 121, and Schedule 4 of the Firearms Control Act 60 of 2000, accused 1, 2, and 4 are found guilty as charged.
Okay, so that was the verdict. On June 5, 2025.
2 weeks ago.
Oh, so very recently. The Eastern Cape High Court handed down its verdict. Diabana Ngangelizwe and Kwaisha were convicted on multiple charges, including robbery with aggravating circumstances, attempted murder, kidnapping, and unlawful possession of firearms. Diabana also faced additional charges of culpable homicide and reckless driving for his role in the fatal crash. However, a fourth suspect, Lungi Makwabongo, was acquitted. The court accepted his claim that he was merely an bold driver, unaware of the intentions of the men he transported. Justice was served, but was that enough? Will this conviction serve as a deterrent, or is it just one case in an ongoing epidemic?
Farm murders are more than isolated crimes. They are part of a larger crisis. The justice system must act decisively, and communities must demand accountability. If we don't speak up, these stories will continue to repeat themselves. If you want to support victims and push for stronger protections, consider engaging with advocacy groups, sharing these stories, and demanding action from lawmakers. Justice must not be a privilege, it must be a guarantee.
Hayden Aldred Luck's story will not be forgotten. The victims of this attack deserve remembrance, justice, and accountability. Next time, we will uncover another case, another life lost, another fight for justice. Until then, stay informed, stay vigilant, and never stop demanding the truth.
This has been Blood on the Fields. We're Lucas and Danielle Steenkamp. Please subscribe to our channel if you want to hear more truth about farm attacks and farm murders in South Africa. Like and share this video to help us raise awareness about these disgraceful targeted attacks on our farmers, and to hold our government and the justice system accountable. Thank you for listening.